Yeah. So, good evening, folks. Welcome, Jonathan, our special invited guest. Thank you very much. We're going to be picking up on last month's thread, which Simon introduced us to. Which there's these three ostensibly disconnected things, which actually might be increasingly joined at the hip, and the perfect storm of a tax issue with IR35. An employee contractual issue with the worker status, and this non-negligible duty of care thing. And if you line those things up, it could be a little bit uneasy. So I've invited Jonathan to explore that. So rather than just relying on us kind of making up as we go along, let's bring someone in who knows what he's talking about. So Jonathan, thank you. Feel free to introduce yourself, your business, and have a little plug for what you do, and we'll take it from there. But we won't do a Q&A. We'll interrupt you whenever we feel appropriate with a Q&A, if that's all right.
That's fine. I'm used to that. It's not a problem. Hi, everyone. Yeah, as was said by Kevin, I'll give you a brief précis of my career path. Started out as a personal injury lawyer many moons ago, 25 years ago, and a very small part of my practice was clinical negligence, and a small part of that small part was suing you guys, and it took me a while to see the light, but I saw the light 12 years ago, and for the last 12 years, all I do is represent dentists. So the only thing I don't do is appear in front of the General Dental Council, mainly because the firm I work with aren't one of the licensed providers of legal services to the insurers and the indemnifiers. But everything else, right from buying and selling practices all the way through to stuff that we're going to discuss tonight, partnership disputes, and occasionally defending dental practices who, for whatever reason, don't have indemnity cover. And there aren't many, but there are some. But Kevin asked me to come on and talk to you about IR35 and links with vicarious liability, which, again, back to my days as a personal injury lawyer, I was involved in an awful lot of those types of cases, so they transcend across. But I think, as was said, it's three separate areas, but it's stuff that's very important, each in their own right, and it's a bit like a crossing of swords when all three of them come together. But the IR35 thing, off-payroll working's been around for a while. It wasn't until the 6th of April this year that it started to apply to you guys. Every other profession had picked it up. We all know about the Uber case, but dentists, for whatever reason, escaped. But 2-3 years ago, maybe more, I was hearing a lot of things from clients and contacts that associates were getting letters through the post from HMRC asking a number of questions, all in relation to this subject. And it wasn't compulsory for a response, but I think a lot of dentists got a bit scared when HMRC started writing, as anybody would when HMRC writes to you. And they were gathering evidence. Yeah, they were gathering information. That's basically what they were up to. And it was on the basis of, let's see whether or not we can push IR35 into the way of the dentists. And it's with us now. So the off-payroll working rules make sure that a worker, so ultimately an independent contractor, which is what all dentists effectively are, broadly pays the same rate of tax and national insurance as an employee would. And the rules only apply if the associates provide their services through a professional services company. So just taking Simon as an example, if Simon was employed in his own name by a principal, not through Simon Thackeray Limited, which was a totally separate legal entity, and all it was an umbrella company that sat there and basically was a vehicle for him to work through, he would be an off-payroll worker if he was doing it that way. If he was doing it as Simon Thackeray, actually working for a dentist, that's a completely different situation at law. Ultimately, it's still Simon doing the dentistry, whether he's doing it through a PSC or whether he's doing it in his own name. He's at the coalface. He's the one treating the patients, and he's the one who has control, which is one of the things that CEST, the tool that HMRC have brought out, does talk about. So it's not about the physicality of the dentistry. It's about the behind the scenes, so to speak. And the PSC, a professional services company, isn't defined anywhere in the law. It's effectively a limited company that the worker, and again, Simon, sorry for using you as the example, that Simon's in control of and that he has some interest in. So he ultimately would be the managing director, the shareholder. He might have another shareholder. Shareholders are a different thing to directors. But he is in control. He's the one that decides what that PSC does when it does it. And the PSC is effectively the intermediary between the practice and him. And legally, it sits there as a totally separate thing. Now, most cases, the clients, and the client is the practice. The client is the person who's receiving Simon's services. So it's the dental practice in this case. The dental practice is normally responsible for determining the status of the employment status, if you like, of a worker. But if a worker is providing services outside of the public sector, which obviously all of you are, you all work in the private sector, admittedly for a public body if it's the NHS, then it's the PSC, the intermediary, that ultimately has responsibility to decide what the employment status is. And this is where the CEST tool comes into play. And it's quite a strict test. I mean, anything that's brought in by HMRC is going to be strict, and it's not something to be scared of. Admittedly, that's, it's easy for me to say, but there are a number of issues that the CEST test addresses, and I'll go through them one by one and as simply as I can. The first section is about work, and it's looking at whether you operate as a dentist on your own behalf or whether you're operating through a limited company, and whether or not the work is classed as self-employment. And it depends as a principle on how you're engaging that associate dentist. So if you're engaging Simon as Simon, then the stat is a different status than if you're engaging Simon Thackeray Limited. And where it's the limited company and where it's off payroll working, that's a positive as far as tax is concerned, because your tax status is what it's all about, and the tax status will change ultimately if you go from being self-employed as a worker now to being classed almost like an employee, and the Hughes and Rattan negligence case touches upon that on the vicarious liability side. It also goes on to ask the HMRC tool whether or not the associate dentist holds some form of office. So company director, company secretary, and that sort of thing. And obviously the answer is going to be no, because if the dental practice is trading as a limited company, the limited company at law is an entirely separate thing to the dentist per se. So the HMRC will look at that as a totally separate situation. So they're not for tax purposes, and they're always looking at this for tax purposes. They're not looking at it anyway else. So it's in your interest if there's a PSC in place. They're also keen to know who's doing the dentistry. So most of the time you'll be doing it yourself, but, and God forbid one of you fall ill and you have to get locum on board, who then's involved in responsibility for getting the locum engaged? Does your associate contract say it's got to be you who finds the locum? And if you can't find the locum, the principal will step in and find somebody? Or does it say that it's the principal who's going to find the locum at all times? And then it comes down to who's paying the locum. So if it could be one case where the principal's paying you as an associate, and then a percentage of what you're bringing in goes to the locum, or in some cases, the locum might end up getting more, which means you're out of pocket. Or is it the case that the money's going straight from the principal to the locum, bypassing you? So HMRC will want to know who's actually paying that locum. And it's important to, not so much to be honest, but to be upfront with them and tell them what the actual working practices are. Because if the contract says that the associate needs to engage that locum, but the dental practice went ahead and found that locum and paid them themselves, then the question should be answered accordingly. And you've got to explain that to the HMRC, because they will want to know from the contract perspective if it's different. So if in your contract it says in the event...
I was going to say there, is it okay if you assist the associate in finding a locum, even though it's their responsibility to then engage them?
Yeah, because ultimately, if you have an input and you say Jonathan Jacobs is the person I would recommend, and then the principal can turn around and say, well, okay, I'll take that on board, but I think Simon Thackeray is the best bet for this practice. So ultimate control still lies with the practice, but there's no reason why you can't recommend. It doesn't affect the legalities. There would be a difficult situation arising where Simon, if you said to the principal, I think such and such a person is going to be best for treating my patients, and the principal turns around and says, well, actually, no, I think this other person will be better. They're your patients. You've got the relationship with these people. You know how best to deal with them. So there's a bit of a conflict arising here if that happens, because then you're left in a position where you want to recommend somebody to take over your jobs whilst you're away, and yet the boss is saying you can't do so. So what's the knock-on effect? It doesn't bode well for a working relationship. Now that leads nicely into control, which is exactly what we're talking about now, and that there are essentially four things. Does the organisation have the right to move the worker from the task that they're originally engaged to do? Now, you as dentists, you're highly skilled, you're professionals. You're coming into a practice to do dentistry. You're not coming in to be a receptionist or a nurse or a cleaner. There are specific tools and specific skills and expertise that you spent 5 years plus at dental school, plus learning, and no practice in the country would bring you in and expect you to do work that you were not highly equipped and skilled for. The next thing they'll look at is, does the organisation have the right to decide how you work? Now, in the vast majority of cases, the only duty the principal's got is to give you patients to work on. And after that, you're in control. You're the one who determines with the patient what the treatment plan's going to be, how it's going to be paid for, how long it's going to last, and it's an agreement between you and the patients. And it's not for the principal to get involved. Believe me, there are some principal dentists who do, but it's not their role. It's their role to effectively, what they're doing is they're delegating that patient to the dentist. But there is a non-delegable duty of care that all the principals have over every patient that walks through that practice, because if that duty of care to the patient didn't exist and didn't sit with the principal, then a whole deck of cards falls apart. Where does the patient go if there's a negligence claim? I don't sue dentists, as I've said, but I know enough about that area to know the vast majority of clinical negligence cases now are being framed in breach of contract claims, breach of contract against the principal, not necessarily against the direct dentists who are doing the work.
Jonathan, can I just clear something up? We're talking about the clinical relation here between the relationship between the associate and the patient. Okay, so the principal, like you say, is effectively delegating that clinical relationship to a contractor.
Yeah.
Right.
Yeah.
One of the things that we explore a lot as a group is the relationship between principal and associate. But I'm not talking about the clinical relationship. I'm talking about attitude, teamwork, contribution, giving a monkeys, right? You see where I'm going with this? Is that a separate thing? If you work here, I expect you to be nice. I expect you to be part of the team. Does that suddenly mean I'm controlling you if I was your boss? Where do we draw the line?
I think it's not. That's the question's not so much a legal question. There are legal connotations to it, but it's a semantic and human question, effectively. The answer I would give in any workplace, whether it's dental, legal, accountants, whatever, it doesn't matter. You have to be able to work as a team player if you're in that environment. And even in the confines of a dental surgery, the dentist isn't on his own. He's got the nurse or nurses, and he's got the hygienist, and it's like a little sub team within the team, so to speak. So although every dentist is effectively working on his own, no dentist can do the job without having a nurse holding the implements, passing the apparatus. Unless, of course, let's put it this way, I wouldn't be a patient of a dentist who tried to do it all themselves.
No.
And also the chaperoning elements of it as well. But the answer to your question is I don't think any of this detracts from the fact that the associates have got to appreciate that if they're going to be working in someone else's business, yes, they're not relying on that person for the patients and the work. But they're not going to have that relationship grow if they're not prepared to give a bit.
Yeah, fine. Okay. I mean, that is what I was kind of hoping you would say. But I mean, as a non-clinical person in this conversation like yourself, we do spend a lot of time exploring the relationship, if you like, the way we do things around here. And always been that little, well, hang on a minute. I think what we're saying is this is not about you're a complete independent entity, if you like, to just do your own whatever the hell you want. That's not what we're talking about here when we're talking about control, is it?
No,
you're also talking there about the GDC standards that they expect you to work under as a professional, and one of those is to be respectful to other members of the dental team.
Yes.
So there's an immediate caveat there,
right?
That it's sort of, in my view, there it would go beyond what a strict employment law definition of you controlling their behavior. You are perfectly within your rights to have a consideration as to what normal behavior you would expect from somebody. The grey area comes along when you start saying, well, this is how I expect you to construct a treatment plan to present someone. This is how I expect you to do an examination. Really, it should be, I would expect an examination to have these components in it, but how you go about investigating those components and presenting them, if you're too dictatorial about it and prescriptive, you really are starting to grey the fact that you are now working to the same standards and style as somebody else, which could be the grey area. And it might only be, I mean, Jonathan will have a lot more experience on that, but it might just be something as subtle as that can turn it from, you were pretty much self-employed, but now we've put that in and you've got to buy, I'm providing you with this logoed uniform and you're going to do this examination in that way. It could be something as subtle as that changes the relationship.
Sam, everybody, that there are some very, very succinct words in one of the many negligence claims, vicarious liability claims that have been flying around. And I don't remember the name of the judge, but he talked about the relationship being akin to that of employment.
Yeah.
And that's exactly what Simon's talking about. And he's spot on, because it's where does the line draw? And if the principal is effectively laying down the rules as to how an associate should treat their patients, then the next step on is if something goes wrong, who's going to end up carrying the can?
Yeah.
The associate solicitors will say it's the principal. My guy was being constrained. My guy could not work on his patients the way he wanted to. He's been 20 years a dentist. He knows what he's doing in this field, and his hands are being tied behind his back. Liability is denied.
I think that was Brakenbury and Crode. That was a case.
Yeah, it was.
Yeah.
Oh, hello. We've opened a can of worms now, shall we? Mate?
Unmute, mate.
Hello. Sorry. Hiya.
Hi.
You mentioned that a dentist 20 years might know what they're doing. What happens if they don't know what they're doing? And as a principal dentist, you unearth things that are not potentially in the patient's best interest, maybe in the financial interest of the said associate. So then we talk about being prescriptive, but actually are we just upholding standards of care? And then does that make somebody who thinks they're self-employed feel like they're not self-employed?
Again, it's one of the many grey areas. It's a difficult one, but it's a situation which I'm assuming is arising in many practices. I mean, the simple answer, I suppose, would be, and this is assuming that the contract is not so much per the BDA model, because the BDA model agreement is it's okay, but it's not brilliant. But assuming the contract that the associate has is per that contract, then if the principal is that upset that the reputation of the practice is being affected, that his reputation as the principal is being affected, that the patients are going to start complaining, complaints then lead to negligence claims, the easy answer is to serve him with notice, and in 3 months he'll be off. The difficult way, and again, it depends upon how the situation has unraveled. The difficult thing is to sit down with somebody and try and exercise control, because you can't control somebody who is technically at law self-employed. So this is the whole thing about why self-employment in dentistry has become such an issue. Because if an associate is coming into work at the same practice 9 to 5, 9 to 6, 5 days a week, being given a list of patients by the principal, and doesn't have another job outside of that practice, how is that not employment? Because it is ultimately that sort of situation. And all these strands that we've mentioned tonight, the IR35, which there's still a little bit more to come. The Uber case, and the Hughes and Rattan non-delegable duty stuff. It's all interwoven, and the theme running through it is all about what is the status of a dentist, not the principals, the associates.
I kind of think that the biggest issue with associates is if a principal tries to exert any form of control, which might be to increase standards or even increase revenue, that is deemed to basically effectively make them like Uber drivers and workers. Like, you can't set a price list. You can't tell them how to not. If it's an Uber driver, they have to charge a certain price. They have to abide by Uber's conduct of not molesting the passengers, or beating them up, and all the other things. And so it's the dentistry world. It's kind of similar. It's like, please abide by the rules. Is that making somebody a worker, or because I get the feeling that CQC and GDC want us to set practice policies, but we do need our dentists to follow the practice policies. You can't go, well, we have a
Shamik, are you a principal?
Policy against.
Are you a principal?
I am a principal. Kevin will also tell you off record why I have some vested skin in the game.
Yeah, everyone here is a principal,
right?
Yeah.
Or a partner.
Yeah, I mean, you're right. Associates can't have their own pay scales. You can't. The practice's reputation would go down the tubes if it had half a dozen associates and half a dozen different price scales for the same treatment, because the patients would just say, well, hold on a second, the dentist in the next surgery is charging £30 less for the same thing, and they just not going to him. So is that control? Well, yes, ultimately it is. But in terms of what we're discussing, the CES tool, HMRC accepts that the answers may not always be crystal clear, because there's so many parameters in the dental surgery that present that picture that actually it is really an employer-employee situation, regardless of the fact that the dentists have still got to have their own indemnity cover, for the varying reasons that have all been tested out as far as the vicarious liability and non-delegable duty cases are concerned. But it's a hard ship to steer. I mean, I'm not a dentist, and if you gave me a drill and said, pull that chap's filling out, I wouldn't know where to start. But I know enough about how dentists work because of the work that I do. So, but every associate's different. Every case, every situation is different. And if I had the situation, or I was seeing a situation where there were no dental practices in the country with any disputes whatsoever with their associates and the working patterns, and everything was running 100% of the time absolutely brilliantly, I'd be scratching my head and thinking, how? Because it's not the case. This is just something that's jumped out of the page literally the beginning of this month, and everybody is clamoring to think, are my agreements tight enough? Am I protected?
Hi,
Can I
Beth.
ask a question? Sorry, I might have misheard you, but this idea of different people in the practice charging different amounts for similar treatments, I absolutely understand the principle of it. But if you related that to a law firm, the senior solicitor would be charging more an hour than the junior solicitor who's newly qualified. If you're in a hairdressing practice, you go to the senior stylist who's way more experienced, they're going to charge more for their time than the junior stylist. I have the model where I have therapists, I'm the principal, so I don't have associates I have in the past. But I just wonder if there is, maybe I misunderstood what you said.
No, I think I don't think you did, but I think what we're saying is if it's just random, that's when it creates a problem. You know, I think you're right. You can have tiers of pricing per hour or whatever for different people. That model is applicable, as you say, in other professional services. But I think the reputation, I think what you're saying is, Jonathan, just to clear it up, because we've had this conversation before, Beth, is you can have different prices, but why and how? I think I'd be more concerned if there was somebody in the building going, and for the benefit of anyone listening without the video, I'm doing that thing when you just sort of lick your finger and stick it in the air. I'll charge that much. That's a reputational. Yeah. That's a reputational.
Fair enough.
Does that clear it up?
Yes, thank you.
Yeah, I mean, put it this way, when you get on the bus back from Heathrow shortly, Beth, you'll be charged a fixed price, won't you? Okay, the driver's not going to make it up.
He might be a senior driver, very experienced.
Sorry, Jonathan. I told you. I promised it would be fun. I never said it would be easy.
Yeah. So I mean, we're talking about control. So HMRC, you know, as well. We've spoken about pay rates, but HMRC wants to know about working hours and who's deciding those. You know, is it the practice or is it the associate? Is the associate saying, "Oh well, it's Tuesday tomorrow, so I'm going to go in at 12:30 and I'll work till 3 o'clock"? Or is it the case that and we know it is the case that the associate's contract will have the working hours in the contract? Most of the contracts I see, it says 9 to 5 every day, and they don't block out that and put down the right hours, because most associates won't work 9 to 5 5 days a week, but that's what the VDA model contract says they do. So there's that. That is a point they'll take into account, and they'll want to know more about. And then again, it's the same as we've discussed. Does the organisation have the right to decide where the work's done? Now, this probably more applies to the groups. Doesn't apply to single-handed practitioners working out of one practice. So I don't know. Take my dentist as an example. Would my dentist, at a whim, move somebody from a practice in Salford, where I live, over to a practice in Bury? Probably not, because they're in that area. The patients know them. There is a connection. They're probably not local to the area, but dentist and patients, the relationship, you all know, is very, very personal. And personally, I hate going to the dentist, and everybody thinks it's hilarious with what I do for a living. But I trust my dentist, and there's an awful lot of trust in this profession. And if a patient doesn't trust the dentist, what's the patient going to do? They're not going to stay. So it's, I mean, I've seen it happen with the corporates, that they do move dentists around, but it's rare. It doesn't happen often. So it's unlikely that the dentist is going to be asked to be a nurse. Very unlikely. It's even more unlikely they're going to be asked to do reception duties or be a nurse or do the cleaning. So, because what benefit would the practice be taking somebody on? Why are they taking that person? They're taking them on to be a dentist. They're not taking them on to do anything else. And it's not, as we've talked about previously, it's not the case that the principal currently is deciding how the patient should be treated or shouldn't be deciding. But is there going to be a shift in that direction? I mean, I can't give you an answer one way or the other. I'm sure there are dentists out there that would love to have control over absolutely all the associates and how they're treating every patient, but that would become very unwieldy, very difficult to control, but it would be controlled. And it's not something that really helps the associate's position.
There is a move though now. I noticed. Have you seen the new BDA contracts? They have the
Yeah.
option.
There's two different contracts that have come out.
Exactly. You can have a worker contract or you can have a self-employed contract.
Yeah.
And, you know, it does make you think, is there a move for some associates to want to work in that manner? I actually asked my associates a question because I was interviewed by Practice Plan for something similar to this. And I decided to ask the associates, I said, would you, all things being equal, want to become self-employed, want to stay self-employed, or if the option was there, would you prefer to be employed, knowing that that would probably reduce your income because of the increased, increased national insurance and taxation aspects of it, and the fact that I would then be dictating everything that you did? Would you want that option? And every single one of my associates said, absolutely not.
Yeah.
Because they've got very flexible contracts. They do, you know, they do work, particularly when they want, which sometimes can be quite annoying when you think, well, you've taken another day off, but you know, you can make it up or not. But I think there's probably an increasing number of people, maybe younger associates, who perhaps want that security, especially after what happened during COVID. Perhaps some of them want this security of being employed, and perhaps this is where this model might
There's something different though, because a worker status is still self-employed to an extent.
Not necessarily. Worker
No,
status.
but the BDA contract, I might know. I won't. No, I do know some of the legal people at the BDA for other reasons. But the worker status for dentists is dentists still want to be self-employed, but the worker status bit is not actually about being employed. It's about a little bit like Uber drivers, in that they can still clock in and clock out and choose their hours, but the worker status is that they have to do the work in a certain manner. And that's where they're still self-employed because they get to choose for tax purposes.
It's a tax question. The worker status is a tax question. It's a work question, admittedly, but it's a tax issue.
But the BDA contract is more of a worker status issue if there were, like, for an employment status tribunal issue rather than a tax issue.
The current BDA model contract, it is a contract.
Not good.
Well, we know it's not good, but it's obviously not good, because otherwise the BDA would never set out on this road about having two separate contracts, which is where we seem to be going now. But the reason we're going down that road is because of what HMRC are doing. But the IR35 is about off payroll. It's not about worker status. It's about off payroll working. And if you are off the payroll and working through an umbrella, a third organisation, and the practice is paying that intermediary, then you're not on the practice's payroll. You will and should be deemed as self-employed. But it is a financial question, and you guys all know this. You've all been associates in your time, and you know you'll appreciate what I'm saying next is, and what they're looking at is equipment and apparatus. Who's buying them? Who's paying for them? So when you're an associate, you all probably used loops. Who was buying those for you? Probably wasn't the practice owner. It was probably yourself. And ultimately, every dentist wants a slightly different set of loops. What are the costs were you funding? You were probably paying your own indemnity cover to whoever it was, to the DDU or the MDDUS or whoever it was back in the day. And if things went wrong, yeah, the patient puts a complaint into the practice. Principal turns around and says, it was, I'm sorry, Simon, I know I'm using you all the time. It was Simon's patient and it's his responsibility. So Simon's the one who ends up getting the letter, and he has to then go off to his insurers and say, oh, somebody's making a claim against me. rather than an employment situation, which if it shifts, then we'd be in a position where the letter came in from the patients, and it would be the principal who'd have to pass it across to the insurer and say, we've got a claim here, and under vicarious liability, if negligence is found, it's the employer's, it's the principal's insurers, not the associates' insurers, who are going to have to pay out. And that is another reason why associate dentists will want to stay self-employed, because their pay will come down, not just because of tax and NI, but because the principal's insurance policy is going to go through the roof, depending on how many associates they've got, because they're going to have to pay an increased premium for each one. So, and then, you know, things like the GDC, who's paying that? You know, when you were an associate, was your principal paying your GDC registration? Lucky if he was, but I suspect he probably wasn't. And then it comes down to the pay, and certainly in 12 years, I've never seen it once that an associate has been paid a fixed amount. Associates get paid a percentage. And when I first started, it was generally around 50-50. And I know it's come down a bit, and in some cases, I've seen it come down to 30-70, 70% to the practice, 30% to the associates. But on the whole, it is not a fixed sum. It is not a fixed amount of money that you're getting paid, and you all know that. And that's it. That's, well, as an associate, that's in their favour, because it's based upon the work that they're doing. It's not based upon the fact they're turning up for work and they're doing their hours and they're getting paid, whether they sit there in the surgery twiddling their thumbs and reading a magazine, or whether they're actually physically at the chair treating a patient. HMRC are very keen to know what sort of responsibilities they've got as well.
Jonathan, could I just come in there with payment? Would using a sliding scale actually help show more of a self-employed basis? Because then, you know, you're saying they're not getting a fixed amount, but they're getting a fixed percentage every month. They would say be getting 40%.
Yes.
But obviously, if they performed differently, then, you know, they would maybe get 47%. If they performed poorly, they maybe get 33%. Would having that degree of pay variability just firm it up a little bit more in the self-employed point?
Yes, it would.
Right.
It would, because it effectively becomes like performance-related pay.
Yeah.
But then the flip side, Simon, is this, and I'm thinking like a lawyer, as you have to do, thinking about the negatives as well as the positives. It's incentivized, and who's controlling the incentivization? It's the principal. So you everything, every well, I can't remember whether it was Newton or whoever it was. Every action has an equal and opposite reaction.
Newton's second law.
Correct, and that was physics.
Based on that,
physics from school.
Jonathan, based on that, can you one of the tests of being self-employed is that you can run at a loss. So can you in a contract say you're self-employed, percentage this, whatever, we call it a license fee, whatever the bloody term is, but can you stipulate that you're entitled to use the room? We make the facilities available from 8 a.m. to 6 p.m. You can choose them as you like. We just ask for you are paid on the percentage with a minimum license fee of X. So because if they go on holiday, that will enforce they either run at a loss or they have to hire a locum.
Well, that in essence is a franchise. When you're paying a license and a percentage, that's a franchise model. Partly.
The problem is that everyone calls it a license fee, which is I don't know if that's a BDA.
At law, I hear what you're saying, but it isn't a franchise. I mean, yes, this license fee thing is an odd term. I know exactly. I hear exactly what you're saying, Shamik, and have exactly the same thoughts about that. But if the associate's running his affairs through a professional services company, and the company itself is running at a loss, then legally they're an entirely separate entity. So as long as you're getting your license fee, whatever you want to call it, from the PSC, then the arrangement should stay in place. In terms, you should be happy because you're receiving the fee that you expect to receive. If the company's own financial affairs, the intermediary's financial affairs aren't strong, then that's not your worry. But ultimately, It becomes your worry because if you strip the PSC out of the picture, who's actually doing the dentistry? Because the PSC, although at law you've got the PSC at one side and the dentist at the other side, the reality is that PSC and dentist are one and the same.
Still don't know. Can you introduce that into a contract?
A contract is a document that's agreed by both parties to a degree. To a degree, if you put something in the contract and your associate says, "Yep, that's reasonable, that's fine," or said, "Oh, I'm not sure about that," and you say, "Well, you're fine, go off and see a solicitor, get some advice," and he comes back with confirmation that it stacks up, and that maybe I have to turn around to the associate and say, "Yeah, looks all right to me," then yeah, but you can't unilaterally impose terms on an associate that are derisory and ultimately very, very difficult to achieve, because that would be seen as an unconscionable contract if it went to law. So you have got to be careful, and I do see it all the time. Contracts that come across my desk that I'm amazed at why the associates signed them, and it's clear that they've just looked at it and they've squiggled their name on the document. They've not even thought about, should I go off and get a third party to look at this and give me an objective opinion as to what exactly I'm signing. But then again, in the NHS, the GDS contract in 2006 came and no one signed it, and everybody started working under it because there was no choice. So the HMRC will collect all this information together, and effectively it's like a drop down, and it'll drop down with an answer, and the answer will be one of three things. It will either be self-employed, employee, or not sure. And the HMRCs have said if the trail is followed properly and the information is plugged in properly and it still comes out as an unsure, that's fine. They will accept that as an unsure. Now, as a lawyer speaking, and I had this just the other day, unsure if the client is the associate, unsure to me is a good answer, because it means the HMRC can't make a call one way or the other. So if they can't make a call one way or the other, this is me talking to the associate, you are as much likely to be self-employed as you are employed. So don't worry. But if it comes out as employed, that's then a problem. I haven't seen it yet. I mean, let's face it, it's only been in dentistry for 13 days. But, you know, things will change. But it's like everything. We're in a state of flux with IR35. It's with us. It was coming. There will be litigation arising from it. There's bound to be, just like there was with the Uber situation. But it pulls so many different areas together, and it's not the most exciting topic to talk about. It's not the most exciting topic to
litigation from who, though?
Exactly. Litigation from associates who are not being paid properly. Litigation against the HMRC in case they've made the wrong decision.
When you say associates not being paid properly, like in terms of what, if that's when a practice deems their non-payroll and strips out
if a practice deemed them wrongly. No, if the HMRC came to a decision that they weren't off payroll and it was patently obvious that they were and they'd got it wrong, and they wouldn't budge, because the HMRC don't like changing their minds once they've made a decision. So I can foresee there being cases. We'll wait and see. It's a work in progress. But that's, to be honest, all about IR35. But the other two topics that we were talking about, I guess back to Kevin really, as to time-wise, how much time we've got to touch on those.
We do normally try and keep this to an hour. I know Viren's itching to jump in with a question. So should we do that and see where it goes?
Can we just say happy birthday to Viren, because he's obviously got those two balloons behind him. There must be some kind of celebration.
Happy birth of son.
It's not birthday. I had a little baby arrived 2 weeks ago.
Oh, congratulations! So it is a birthday.
Congratulations.
Yeah,
it's a birthday,
it's not mine.
Literally.
Just not yours, Viren.
Just not mine.
Viren has to be mine as well.
How's the sleep? What's the sleep situation, Viren?
Yeah, pretty good. 4 or 5 hour stretches we're getting. So not bad.
Now, isn't he?
Yeah.
all as old as dad's thinking.
I say that, and then tonight it'll be rubbish. So.
What's the question,
I was going to ask. So just hopefully a quick one. So just on the CES test, do we have to do that as a principal for every associate, or does the associate have to do it themselves?
It's the PSC's obligation to carry out that test, but there's nothing to stop you as the principal doing it as well. But the expectation is that the PSC should do the CES test, because if you think about it from the PSC's point of view, they're wanting the HMRC to come down on the self-employed side, and they're the ones who we're talking about, and they're the ones who should have the information to hand. But there's nothing to stop you as the principal doing the check, because then ultimately, what happens if the associate who's running the PSC turns around to you and says, "Oh, well, everything's fine on the CES test," and doesn't show you the result? And you just think, okay, that's fine. Then you go off and do it yourself with all the information that you know there is, and you come out with a different answer. And then what
That's
happens?
my only worry, is if they go and do the test themselves and they plug in the wrong questions or wrong answers, whatever.
Plug in the wrong questions deliberately, accidentally. It could. Equally so, there's no guarantee that everybody who sits in front of the laptop or their computer answering these questions that the HMRC have asked will fully understand the information they're being asked for. So it's probably always worthwhile the principals carrying it out as well.
Should we just do it together, do you think?
Depends on who the associate is, I would guess. If it's somebody who you get on with really well and they trust you and you trust them, fine, do it together. If it's somebody who you think is going to be really abrasive if you get the wrong answer, or you get an answer they don't like, then maybe you should do it on your own.
Yeah. Because I think as principals, we can come up with different examples and things of why they are more employed.
Yeah. It's a very subjective thing, because no two associates in a practice will unless of course you're in a practice where you're going in with Viren Vislani dentistry, and then you're saying, "Hi, welcome to Viren's dental practice." There is a case that dealt with all of this, and it's obvious to all intents and purposes that everybody looks like they're being employed, but in reality, there's this issue that we're talking about now. Right. But it's probably worthwhile if you're anxious about what the result might be, just for the sake of your own sanity, to do it yourself and see what happens. And you'd like to hope that in every case that it'll be the same answer they get doing it themselves. But then I suppose you've got the issue, well, what if it's not? How do I then approach it? Well, actually, my results say that you're employed, and you're telling me that your results say you're self-employed. So where do we go? How are we going to resolve this? So again, and this is me as a lawyer thinking. This is how I'm trained. Like you guys are trained with teeth. This is how I'm trained to think. I'm trained to think on the positives, but I've got to think about the negatives, because that's why I'm here. That's why I'm here to talk to you about both.
Jonathan, thank you. What I'm going to sort of point over there 3 years down the line. What's the longer term? So there's no right or wrong answer to this, and I appreciate asking a lawyer to do a bit of a crystal ball thing here. It's like asking dentists to do financial accounts and planning, right? It's just alien to them. But what's the 3 year horizon looking like? Are we going to finish up with, what are we leaning towards? A whole bunch of dentists that want to be employed. Simon's saying not from the questions he's asked. The middle ground, the worker status. Where have we got anything? I mean, if we look. What fascinates me is IR35 was a thing in other sectors. I know before I came into dentistry, so I was kicking around the construction sector when I was financing construction businesses. Are there any clues from other sectors as to where this is going to go? If dentistry, like you say, is a bit later.
I can't say that there are any clues, because dentistry is like no other business. The way it operates, it is if you look at the professions, just per se, so law, accountancy, medicine, pharmacy, etc. Dentistry operates very differently even to the professions. It's an odd business in terms of the way it's structured. But in 3 years' time, things will have bedded down, certainly, because we'll be 3 years further down the line with this thing around. The majority of dentists, I don't think, will have the status changed. I don't think there'll be a massive change, but there's going to be some. There's going to be some who will find themselves at a bit of a crossroads. There'll be some principals who find themselves at a crossroads. What are they going to do in scenarios where it turns out that in reality a particular associate is employed? How's that going to play out? So I think, like with anything, the first 12 months will be quite an interesting road. Hopefully not too rocky. But I think we will see, from our perspective as solicitors, we will see a number of disputes. We'll see disputes between principals and associates. Go back to what we're talking about with Viren. You know, he says one that my school of thought is this, and the associate says, no, actually my school of thought is that, and it's north and south. We'll possibly see some disputes with the HMRC, questioning decisions. We'll possibly see a review of the procedures in terms of how IR35 applies to dentistry once the first period is over and done with. And we will also see a development on the, I know we've not had too much time to talk about the vicarious liability and non-delegable duty stuff, but we'll also see a development on that front as well, because if there are numbers of dentists who are being reclassified as employed staff, then that's going to affect the vicarious liability issues. It's not going to affect the non-delegable duty stuff because that isn't changing. Principal dentists are going to have a contractual duty of care to their patients, whatever. And the standards for the dental team marry up with that anyway. So it's really a little bit like a ball juggling exercise and watching what's going on with IR35 and watching how it's going to kick in and impact on vicarious liability and the non-delegable duty. And they're all, you know, hovering around at the moment, and it's a bit like an interplay between them. So, I mean, I can foresee coming across my desk matters which are going to cross over all three areas potentially. So you know, like you say, I haven't got a crystal ball, and if I had, I would tell you what the answer is going to be. But we are in a state of flux.
Well, I'm going to ask you a really cheeky question, if I may. Okay, and you'll get this because you're a patient and everyone else is a dentist. And when patients don't know what the hell to do, they say to the dentist, "What would you do if you were me?" So I'm going to throw that one to you, if I may, Jonathan. Okay, if you had a practice right now, and you've got a couple of, you know, associates in that classical sense on the 30–40%, what would you be doing to you know, to what appears to be future protect ourselves here? What would you be doing? What would you be focusing on?
Well, it's all about, like you say, protection. If it was if I was looking at a situation where the structure of the practice I was running appeared that it was likely that maybe one or more of the associates was going to get a shock from HMRC and find out that actually they're employed, I will be thinking, oh, right, okay, so that's going to affect my tax liability, my national insurance liability. It's going to affect my insurance premiums for indemnity purposes. It's going to affect the claims. They're going to all start being directed towards me. And contractually, I need to be protected. So I would be looking at the associate contracts and I'm not saying ripping them to shreds, but I would certainly be taking advice from a lawyer and saying, well, look, okay, this is what I've got at the moment. This is where I think it's going, because HMRC probably will keep the principals informed about what's happening. I'd like to think they will. What do I do? Because it's too late. And it doesn't matter whether it's dentistry or any other business. It's no good being reactive. And unfortunately, when people like the HMRC start shaking the bells, then it provokes reaction. It doesn't provoke proactivity, which is always far better. So speaking to you guys and putting the message out there is always good, because it hopefully it makes people sit back and think, right, what if it does happen? What do I need to do? Not waiting for it to happen and gosh, how am I going to crawl back from that position? And the way to deal with it now is by looking at your associate contracts and even if you think you need them, you don't need them checking, just for peace of mind, getting them checked over and are they going to protect me in the event that HMRC come down on the side of employment, or what happens if vicarious liability development continues. I need to think about my business. I need to think about how best I'm going to protect this practice, because I don't want to be coming into work next week and finding all my dental staff are now employed and I've got a shed load of tax and an eye to pay. oh, and what about the indemnity? Because that's a worry, and it's a stress. It's that everybody knows who works in the profession and around the profession. It is the most stressful of all the professions. And why have extra stress? You don't need it. You've got enough of it already.
Well, we do always try and run these things to time. That has brought us to, I think, a very powerful conclusion. We probably could spend more time exploring this, but I think we probably also need to just let the sieve settle a bit. There's a lot to take in there. So unless anyone's going, yeah, but I really want to ask this question, Kevin, I'm going to wrap things up. Jonathan, thank you.
No, well, I think the easy thing, Kevin, to say is that you've got my contact details.
Yeah.
So if anybody goes home or is at home already and thinks about an issue that they want to throw by you or via you to me, that's absolutely fine.
Yeah, and that's very kind of you, and we appreciate that. So I will wrap things up. There will be a recording. I'll upload it for our clients because I will do the video on it as well. I'll upload it to the shared Dropbox drive, and I guess somehow I'll wind it away to you, Jonathan, as well, so you can use it. And yeah, thank you all very, very much. I will stop the recording here.